Hi, everybody. We're going to get started. Welcome to the NYU Law Forum, which is sponsored by Latham & Watkins. I'm Jennifer Weiss-Wolf. I'm the Executive Director of the Burn-Bound Women's Leadership Network, which is one of the co-hosts for today's discussion. In a moment, I will turn the floor over to our speakers, Chris Hayes, host of All In with Chris Hayes on MSNBC, and NYU Law's own Melissa Murray, the Frederick I. and Grace Stokes Professor of Law, the co-creator and co-host of the podcast Strict Scrutiny, and the faculty director, of course, of the Burn-Bound Women's Leadership Network. As you know, there'll be a conversation about the Supreme Court's ruling just over 4 months ago in Dobbs versus Jackson Women's Health Organization, but I just want to take a quick moment to say if folks want to come back at 5 p.m. today, we're going to be doing a sort of part 2 here in Greenberg, a discussion on femtech and digital footprints and all those related concerns in a post-Dobbs environment. Professor Murray will be moderating that panel, and there's CLE offered as well. So we hope to see you back this afternoon at 5, but for now, with no further ado, I will turn the floor over to these folks.
I'm going to be working for my salary today.
Are you?
Yeah, right here and then later at 5.
Oh, yes, yeah.
Sure.
Double booked. Hey, everybody, nice to meet you. I'm Chris. It's good to be here. I love this room, and it's good to be among friends. I thought we would start the discussion with a little prehistory.
Okay.
Because it really wasn't that long ago that a major abortion rights case came before the court. It wasn't a sort of frontal assault on Roe, but it was the most significant case that had been decided in a while. And the court ends up essentially upholding the core findings of Roe and Casey and using the undue burden standard to strike down abortion regulation in whole women's health. And that seems like another lifetime ago, but it wasn't another lifetime ago. It's probably worth just talking about that case to start as like the prehistory, since it wasn't that long ago and it was the last major decision the court had on this before Dobbs.
I was just like thinking back to 2016, to when I had rights, when I was a whole person. A
whole woman.
A whole woman, those were the days. So you're exactly right. Whole Women's Health versus Hellerstedt was not a frontal challenge to Roe, but neither was Dobbs. So it's important.
Well, originally. Right, yeah.
So there's that. But this case was a challenge to 2 Texas abortion restrictions, one that required abortion clinics to be outfitted as ambulatory surgical centers, and a second that required physicians performing abortions to have admitting privileges at local hospitals. And this case was decided during that interregnum period where Justice Scalia had died in February of 2016, but Justice Gorsuch had not yet been appointed to the court. So there was an incomplete complement on the court, just 8 justices. But there was a 5-3 decision. Justice Kennedy, who could sometimes be wobbly on abortion issues, joined the progressive wing of the court to strike down both of those laws. And he seemed to be principally concerned, at least in oral argument, with the fact that the admitting privileges law, which had gone into effect, the ambulatory surgical center law had been held in abeyance, but the admitting privileges law had gone into effect and had the impact of shuttering almost 40% of abortion clinics in Texas, existing abortion clinics, limiting the number of clinics to, I think about 4 were left in the state, which is the second largest state in the union and one of the most populous in terms of people of reproductive age. And so that seemed to be determinative. And again, in Justice Breyer's opinion, that was a big factor. The court struck down those 2 laws, upheld the undue burden standard, but actually gave it more teeth than we'd really seen before. So it required courts evaluating abortion restrictions to weigh both the purported benefits of the restriction as the state had identified them against the burdens on abortion access. So a toothier standard, if you will. In 2020, again, this is after Justice Gorsuch has joined the court, so we're still in a 5-4 bare conservative majority. The court took up June Medical Services versus Russo, which was a challenge to a Louisiana admitting privileges law, which was virtually identical to the one struck down in Whole Women's Health just a few years ago. And there, again, the 4 liberal justices formed a plurality and were joined in the judgment by Chief Justice John Roberts, who made clear, I have not changed my mind about abortion, but if stare decisis means anything, it means that a law that's virtually identical and that was struck down 4 years ago has to be struck down today. But he said he was doing so under the Casey standard and not the Whole Woman's Health standard. So that's where we were in 2020, June 2020. Now, what happened in September 2020 was Ruth Bader Ginsburg passed away. In 2019, the state of Mississippi challenged there are two rulings, one from the Southern District of Mississippi enjoining Mississippi HB 1510, this 15-week ban on abortion. It was affirmed by the Fifth Circuit, made it up to the Supreme Court on cert. They filed their cert petition in, I think, June of 2019. Nothing happened. It's sort of on the court's conference list for a while. The court eventually grants certiorari in this case. In September 2020, Ruth Bader Ginsburg passes away. And interestingly, Mississippi's posture as to this case really changes after the death of Justice Ginsburg. Before, when it's seeking certiorari, it's like, this is a very minor case. We're just trying to figure out if a pre-viability ban on abortion is okay. That's it, just sort of tinkering around the edges. By the time Justice Ginsburg dies and the court has picked up this case and docketed it for the 21 term, their ask is much more aggressive. Now they're explicitly asking the court to overrule Roe versus Wade and Planned Parenthood versus Casey. So, I think it seems to me at least that a big motivator in this shift in posture is a change in the personnel of the court.
Yeah, well, you're saying that very diplomatically. From someone who is watching this much more from the outside, it just seems obviously the case that they didn't have the votes, and then they had the votes, and then they asked to overturn Roe, and then they got exactly what they wanted. The same way that you might want to, overturn Obamacare, and then you can't overturn Obamacare when you've got a Democratic legislature. But then if you elect enough Republicans, then you try to overturn Obamacare because that's what you can do when Republicans wield power. It just, from the outside, it seems just obviously manifestly the case. That's what happened.
Well, or you can't overrule Obamacare in the legislature because you have a Democratic majority and one Republican senator famously votes thumbs down on it. And so you have completely changed the complexion of the lower federal court. So you dispatch it to some district court in Texas and they strike it down for you. And you just hope and pray you can get it done as the case proceeds through the appellate process.
I'm going to ask you a hard question. So we get the leak of Dobbs. Here's the hard question. So we get the leak of Dobbs, the opinion in, is it February, March?
It was in May. It was just before finals.
Okay.
Right? I got a lot of emails.
So we get that leak in May. A funny side note about that is that I had been wanting to spotlight the deliberations over that case and the possible impact it could have on American women, people who can become pregnant, and politics generally. So we had booked in the final block of the show Erin Carmon to talk about it, and then the news of the leak happened in the commercial break beforehand. And
you look like a genius.
But then subsequently, amidst all the speculating about who the leaker was, one of the conservative conspiracy theories that it had to be a liberal pointed to the fact that I had booked Erin Carmon in advance as evidence of the fact that I had foreknowledge of the leak coming. So here's my question about the decision, which basically doesn't change much at all from the leaked version to the actually published version. What is the most compelling aspect of the majority opinion in Dobbs?
Oh, that's interesting. That is a hard question because nothing is compelling about it. Well, first, let me say something about the fact that there isn't a lot of change between the draft decision we see released in May and the final decision we see on June 24th. And again, I think that belies this narrative the court loves to tell about how, we may be from different ideological camps, but we actually make each other's reasoning better because we listen to each other and it makes our opinions better. We listen to the other arguments and then we change our opinions in these exchange of drafts. Justice Alito was basically like, Alito 1.0 version is perfect, no notes, no notes. Let's send it out. There were some additions
Ship
to
it.
Yeah, just some additions to acknowledge the dissents, but he was just like, you're perfect, never change, and I won't change it. So that was interesting. Is there something compelling in this opinion? Actually, I do think there is something compelling about the turn to history and originalism. I think that's a very appealing kind of notion. I just think that it's done so appallingly poorly in this draft. And the first thing that Justice Alito says in this opinion is that there is no explicit enumeration of a right to abortion in the Constitution, and he's looking specifically at the 14th Amendment. And if you've read my colleague Peggy Cooper Davis's work, that's not true. Does it say there's a right to an abortion? No, but this word liberty was explicitly understood at the time the 14th Amendment was drafted to have an anti-slavery ethos. It was an abolitionist amendment. And if the 13th Amendment was meant to abolish slavery and the 15th Amendment was meant to enfranchise Black men, the 14th Amendment was meant to eradicate all of the vestigial aspects of slavery and to make a distinction between what citizenship for free people was versus what enslavement was. And so they looked at enslavement, what were the characteristics of it? Well, you definitely had no control over your own body. You couldn't control your own labor. You were often forced to bear children to expand the wealth of your master. You had no control over your children. They could be sent away from you, sold away from you. You couldn't enter civil marriages that were recognized. And so when they talked about liberty in the 14th Amendment, the drafters explicitly understand liberty in opposition to all of these conditions of enslavement. And so to say that there is no textual rooting for a right to bodily autonomy is to completely ignore this history of the circumstances under which the 14th Amendment was debated, drafted, and then ultimately ratified. And again, the inattentiveness to slavery as a major period in our history is echoed in all of these state-level efforts to ban critical race theory. I mean, even to talk about slavery is apparently to talk about critical race theory. And you can see the thread. If we can't talk about slavery, we can't talk about what the Reconstruction Amendments mean, and we can't talk about constitutional interpretation in a complete and coherent way.
This gets to me one of the great paradoxes, ironies of the conservative court's jurisprudence on substantive due process more broadly, but particularly in Dobbs, which is the kind of grafting of Scalia originalism onto the Reconstruction Amendments, even though the conditions and the original public meaning, to invoke a term, at the time of the Reconstruction Amendments is wildly different, in many ways at distinct odds with the project of the founders.
Yeah.
And of course, no one can name the no one in this room, I would be willing to bet maybe 3 or 4 of you can say who drafted the 14th Amendment, right? We don't put them on, they don't, yes, but they don't figure in people's public memories. They're not on any currency. These are just essentially anonymous to history, like white radicals, essentially is what they were. And so
they were the Bernie Bros of their day.
They were the Bernie Bros of their day. And so I just would like you to sort of develop that a little bit more, because we're starting to see Ketanji Brown Jackson sort of introduce in these 14th Amendment cases a kind of, in this, the affirmative action case that was just argued this week, a kind of radical progressive originalism vis-a-vis the Reconstruction Amendments, which has been entirely absent from the court.
So let me start with, I was at Stanford Law School, I guess it was the summer of 2021, and they have these television screens where they have little things that come in and come out. And one of them is what's the best lawyer joke? And then it flashes, and the answer is originalism. I laugh harder.
I find that funnier than you guys did, but I think
they're such a hard audience. You really have to work for them. And I thought this was funny because, originalism gets a really bad name, in part, I think, because it's assumed to be outcome-oriented. And I think that's a mistake. It doesn't have to be. And I think Justice Jackson is really showing that there are progressive outcomes that originalism demands if you are being faithful to the history and where it takes you. And so, we've seen this in her oral arguments in Merrill versus Milligan. I think we saw it just on Monday in in the way she talked about the 14th Amendment and the Civil Rights Act of the 1965 in the context of the UNC affirmative action case. there is a way to understand the Reconstruction Amendments that can only be understood as a race-conscious intervention. This idea that colorblind constitutionalism is what the drafters of the 14th Amendment were going after as they tried to eliminate the vestiges of slavery is just so stupid. It's like really?
There was a moment in which the plaintiff's lawyer, before the court on Monday, attempts to argue, apparently with a straight face, I wasn't watching, that the Freedmen's Bureau was race blind.
It was
yes, they didn't call it the Black People's Bureau, but
they did call it the Freedmen's Bureau, and no one else had been unfree, so there's that.
But he literally was like, there
was a lot. We can talk about that oral argument. Which I felt was like a ginormous microaggression, but for 5 hours.
But the through line there, when you talk about Peggy Hoover Davis's work and about the 14th Amendment and Ketanji Brown Jackson's questions in a series of oral arguments now, is just the fact that here you've got this Dobbs decision that rests upon this originalism.
Yeah.
It looks to like the history and traditions and entirely skirts past the actual history and public meaning of the text of the 14th Amendment.
They do this all the time, right? So look at Bruin, which was announced the day before the Dobbs decision. It was on Justice Thomas's birthday, and I think this was his birthday gift to himself.
This is the big guns case.
The big guns case, literally the big guns case. He actually says in this opinion, not all constitutional history is created equal. I'm like, well, who gets to decide what's the unequal constitutional history? Apparently, it's him. And so
whoever has 5 votes.
Well, that's the thing. There is this sort of itinerant and selective commitment to history that undergirds the conservative originalist project. And, again, I'm not saying liberals aren't selective and itinerant and, what they cite either. But if you are being faithful to originalism, it does not always yield a conservative outcome.
Right. I think this gets to this kind of, we're operating on 2 levels, right? So there's the rights question about Dobbs, and there's the sort of methodological question layered atop it. And I think the methodological question you can't ignore because the methodological reasoning in Dobbs stretches good faith to a breaking point such that you can't ignore, And of course, this was the thing people always said about Scalia. I was like, oh, look at him with criminal defendants. Like, he doesn't like the outcome, but he's so adherent to his methodology that, he has to find, in the opposite direction. And, they'll cite to Raich or whatever it is, where it's like Scalia's on the side of the liberals. And because he's so
I think it helped in Raich that Scalia was not on the side of drugs.
Yeah, exactly. No,
I think
that's of course what happened in Raich. But the point is that, this has always been the kind of mythos. There's both the methodological undertaking of originalism, right? Then there's the it's done in good faith, it's not outcome oriented. And I do feel like Dobbs broke that, even for people like the people in this room or the people that you're on faculty with who had some thinking that there was something other happening than just purely outcome-driven reason.
That it was principled.
Right, yes.
I think Dobbs really does you have to strain to find the principle in it. It's not true, I think, if you're taking the 14th Amendment seriously, that it's not explicit. I think the idea that even if it's not explicit, is it implicit and deeply rooted in the history and traditions? He skirts over all of these laws that make clear that from the colonial period until roughly the postbellum period, women could terminate a pregnancy without criminal consequence before quickening, this period that I guess roughly tags or aligns with viability. And so, just completely skirts over all of that and instead cites, noted witch burner Matthew Hale.
Yes, exactly. So in terms of the sort of reasoning, I want to turn now to basically the substantive due process grounding and the line of cases. Mm-hmm. And there's a little bit of, it seems to me, the sort of famous good for one ride only proviso in Bush v. Gore, right? Which is, we're finding this a violation of the Equal Protection Clause, but don't everyone go out there running around bringing your Equal Protection Clause suits on voting rights. Obviously, we're not interested in that.
Yeah.
This only applies to getting George Bush elected president, which is the finding of Bush v. Gore. They don't quite do, Alito doesn't quite do that in Dobbs, but he does something somewhat similar about substantive due process in the line of cases, which Thomas explicitly denounces in his dissent. And I'm curious if you could talk about both Alito's sort of not quite good for one ride only, but don't worry about Obergefell, and then Thomas being like, oh, worry about Obergefell.
Well, so, I mean, to be clear, Justice Alito in the Dobbs majority opinion seems to sequester the question of abortion from other substantive due process rights, like interracial marriage or same-sex marriage or contraception or same-sex intimacy in Lawrence. He's like, I don't know if it's quite just good for one ride, but why don't you take a break, don't ride anything now, go eat, get a pizza, and then come back in like 4 years and we'll talk about it. It's really more like that kind of thing.
Right, yeah.
But Justice Thomas, and Justice Kavanaugh in his concurrence also echoes this, and even I think more facilely says, we're not focused on these other rights. Oh, and by the way, women who live in jurisdictions that are inhospitable to abortion now can simply use their right to travel to go to other jurisdictions. And again, leaving out the idea that the right to travel, like the right to abortion before it was understood to be an implied, not explicit right, and question whether this court would find it deeply rooted in the history and traditions of this country. Like, most people lived in Massachusetts for their whole lives. They weren't meant to go anywhere else. Like, we don't know.
Right.
But so I thought that was interesting that Brett Kavanaugh, had such faith in the right to travel. Justice Thomas, though, is literally like, hold my beer.
Right.
And I've never, ever read a Justice Thomas opinion where I was like, thank you. Thank God for you.
Yes.
But I really read this and I was like, thank God, because I have been saying this we've been saying this on Strict Scrutiny. So, one of my co-hosts, Chris, knows quite well. And we've been talking about this forever. And people have been calling us fear-mongering harpies, a particular brand of misogyny for women who dare to speak their minds. But we were like, this obviously has to happen. We said this after the draft opinion, the logic of this decision cannot be limited to just abortion. It obviously extends to these other rights if you take the history that they are parroting seriously. And everyone, so many people were just like, you guys are nuts. You're fear-mongering, you're getting people all upset. And then he writes this, and I was like, thank you, Clarence, which I've never said before. And so he writes in this concurrence, okay, I know the majority said this was limited to abortion, I guess. But I think the entire line of substantive due process decisions is completely bankrupt jurisprudentially, and I would invite the court to take it up at the earliest opportunity. And that's, no one signs on to it, so he's all by himself, but that this is going to be husbanded in the lower federal courts, and that it is an invitation to future litigation. And that's what's coming next. And I think it's probably contraception that's really in the crosshairs, maybe more so than same-sex marriage, although that's coming. I thought it was really, really striking that he left out interracial marriage.
I mean, it really hits you in the face, because he lists the substantive due process line of cases that everyone knows, and he doesn't.
Loving's more of an equal protection case, which might be, why.
There's this long, robust history, right, of critiques of Roe, liberal, progressive critiques of Roe. And it is, I think when you go back to it, I haven't read it in a while, but it is a weird thing to read, in modern times, because it is so sort of frankly paternalistic in its reasoning. The doctor, the woman and the doctor kind of knows best. And of course the doctor is always, a man in this case. And, Ruth Bader Ginsburg wrote critiques of Roe. And of course, Alito gleefully cites some of her critiques of it in the Dobbs majority opinion. And I guess my question is to whatever extent there are jurisprudential shortcomings of Roe, do you understand that as leading to this outcome, or is it entirely a political project?
So, Roe is not a perfect opinion. I think there are lots of things you can say about Roe. And to be clear, Roe was not the only abortion case that was being litigated at the time and that could have reached the court. So there was here in New York, Lefkowitz versus Hall, or Lefkowitz versus Abramovitz, which was being litigated by feminist lawyers, and they literally threw the kitchen sink at this. There were claims that compelled pregnancy violated the Eighth Amendment, sex equality claims, race equality claims, class equality claims. Just a full panoply of potential arguments that could be made. It gets mooted when New York, by legislative fiat, changes its abortion law to be more liberal. It's one of the few states that does through legislative action during this period. So it gets mooted out. The case that Ruth Bader Ginsburg actually thought would be the most appropriate and ideal vehicle for litigating reproductive rights at the Supreme Court was a case called Strzok versus Secretary of Defense, and it involved Susan Strzok, who was a captain in the Air Force who was unmarried and found herself pregnant during Vietnam. And she was an ardent Catholic. She didn't want to have an abortion. She actually wanted to bring the pregnancy to term, but surrender the child for adoption. And weirdly, military policy demanded that she either terminate her pregnancy via abortion or leave the military, which she did not want to do. And Ginsburg thought this was
imagine?
like a federal
Can you
policy
imagine?
requiring abortion. I mean, chef's kiss. Again, Ginsburg thought this was the best vehicle because it was about pregnancy discrimination and employment and religious freedom and due process and equal protection, all of these things.
And also autonomy in either direction,
In
right?
either
Like,
direction, yes.
it is your choice to do either.
Whether
because those are both
or not
different
to
sides.
bear or beget a child. I mean, she thought this would be fantastic. The military changes its policy, and that moots that case out. And that leaves Roe, which is interestingly being litigated by two young lawyers, Sarah Weddington and Linda Coffey, who I think are 3 years out of the University of Texas Law School. And they principally focus on due process and privacy, because there has recently been a successful challenge, Batchelor versus Buchanan, to a sodomy law in the Southern District of Texas that basically explicitly relied on Griswold. So they're like, this seems to work. And so that's what they argue, and they don't argue anything else. And that's how that gets to the court, and it's too limited, for sure.
Right. Yeah, I mean, I guess the question is, and this is both a little bit of a hindsight 2020 kind of like counterfactual question, but also not so much because we now live in a post-Roe world about regrounding rights, right? Is basically, you know, people have talked about these different ways that you can ground the right.
Right.
And I guess I wonder like how much thought you or others are giving to that in the post-Roe world, which is like, what is the kind of, what's the sort of judicial legal trajectory here towards regrounding something that should be a right?
So I, along with Reva Siegel at Yale and Serena Mayeri at Penn, filed a brief arguing that an additional leg for Roe to stand on was equal protection.
Yep.
And we raised this not solely just, you know, the 14th Amendment, but this line of sex discrimination cases that had been litigated initially by Ruth Bader Ginsburg and then later by others that culminated in United States versus Virginia. And we argued that there had just been a broader sweep of understanding various kinds of public policies as species of sex discrimination. And abortion laws were among them, right? Justice Alito is actually the only member of the court that talks about our brief, and it is to dismiss it in like less than a very short paragraph. And he dismisses it saying that all of the precedents of the court counsel against viewing abortion restrictions as a species of sex discrimination that would be violative of the Equal Protection Clause. And he cites Geduldig versus Aiello, which I think effectively has been overturned.
What is Geduldig?
So I'm sorry, Geduldig versus Aiello is a wild decision of the court, which basically says that pregnancy discrimination is not sex discrimination because it's true that women can get pregnant, but they don't have to be pregnant, and they're not the only other people. It's just a wild decision that finds pregnancy discrimination to not be sex discrimination for purposes of the Equal Protection Clause. In very short succession, Congress amends Title VII to include the Pregnancy Discrimination Act, which does recognize discrimination on the basis of pregnancy as a species of sex discrimination. So, and then more interestingly, the court, in a decision from 2003 called Hibbs versus Department of Human Resources of Nevada, essentially overrules Geduldig to some degree. I mean, like there's lots of writing about this. And then United States versus Virginia sort of also expands the understanding of what constitutes sex discrimination. And we argued, like, if you follow that trajectory, it's really hard to figure out how to uphold abortion restrictions, which are kind of rooted in this sex stereotype about women as mothers, right? And if you take that seriously, that's another grounding for this. Alito is just like, see our precedents. And you're like, but dude, you just laid waste to a whole bunch of precedents.
Exactly.
Like, lay waste to this one too. So he doesn't really engage it. Interestingly, the dissent doesn't engage it either. And I wonder if that's because they didn't want to draw more attention to the argument and to get either the concurrences or the majority opinion to engage with it more, because it is actually now being successfully parceled out in state courts where there are either ERAs at the state level and more robust constitutional rights for bodily autonomy and reproductive rights written into state level constitutions. And so it's actually having a second life there.
Well, let's talk about that, because I think, from where I sit as someone who, again, has no specific expertise in this, but just covers, the news and politics, the kind of political ramifications of mobilization post-Dobbs are fairly clear-cut and straightforward in certain ways. You have the Kansas statewide constitutional referendum. You have a statewide constitutional referendum happening in Michigan right now. You also have just very clear choices on the ballot in a state like Pennsylvania, in which there will be a Republican majority in both houses almost certainly, which will send an abortion ban to the governor, and the governor will either, as Doug Mastriano, sign it into law, or as Josh Shapiro, veto it. It's just a very clear, straightforward decision voters of Pennsylvania have about state control. So in that way, the politics and even the sort of legislative or executive actions on this are quite clear-cut. But what the litigation strategy looks like in a post-Dobbs world is not, and I'd love to hear you talk about that a little bit.
I think the litigation strategy right now is to just delay, try to keep access going for as long as you can in as many places as you can. So it's a completely defensive posture as opposed to an affirmative posture, sort of like expanding rights, thinking about it. I mean, it's delay, right? So trying to get injunctions, trying to sort of like tie things up so that you can sort of widen the window where people will have access to this. And again, this is one of those moments where law and politics are going to overlap to some degree, because the outcome of the midterm elections is really going to affect whether the prospect of delay is even possible in some places, right? So, this election is a referendum on Roe. I mean, maybe we've forgotten that because gas is expensive and inflation is, happening. I get all of that, but this is a situation where the Supreme Court took a right that people had depended on for 50 years. And if we don't say, like, I'm not okay with that, not on my watch, it's just an invitation to do more, right? And if it's not registered at the ballot box that people object to this, there's no end in sight to what will follow, whether from the Supreme Court or from state legislatures. Like, all of this is integrally connected to this. And again, if this landscape changes at the political level at the states, it's going to be so much harder to play defense. Like, if states change over, if there are election deniers who also, that tends to like overlap with objections to abortion. Mm-hmm. If that happens, not only are we going to have our elections called into question, but if those elections are ones where people register their distaste for really restrictive abortion laws, that's going to impact abortion as well. I mean, the Brennan Center and the BWN did a program a couple of months ago about abortion is essential to democracy. I think we have often, for too long, thought about these two issues in isolation, but you don't get restrictive voting laws or restrictive abortion laws like the ones we're seeing without gerrymandering and suppressive voter laws. Like, they go hand in hand. This is all part and parcel of the same playbook, and they're integrally connected. And we have to understand them as, law and politics are intersecting here.
Yeah, I mean, what I'm hearing from you is that politics, political mobilization ends up being a more important bind and constraining force on Supreme Court jurisprudence than precedent reasoning, things like that.
Well, I mean, I think it is quite telling that immediately after this decision was announced, there was so much anger and vehement protest around what had happened. And then, a month later, you had the justices hit the huskings, like, we are definitely 100% not a partisan operation. And, like nothing to see here. Of course they're concerned with what people think, with what popular opinion is. Like, of course they worry that their Q ratings are dropping because they depend on the public understanding the institution as legitimate in order to do their work. They don't have the power of the sword. They don't have the power of the purse. They literally depend on the power of public opinion to fuel their own legitimacy.
So that brings me to the next question, which is, if you look at sort of both political and legal remedies for clawing back this right, securing it, refounding it, whether at state level, there's obviously also those who want to go further in the direction of abortion prohibition.
Right.
There was a petition for, there are some who want to basically find a constitutional right to birth for fetuses in the 14th Amendment, that they're persons as described in that. That's the ultimate sort of shoot the moon strategy of certain parts of the anti-abortion right, I think.
I think it's closer than we think.
Yeah, so what do you think about the prospects of that?
Well, I think it's really telling that in his opinion, Justice Alito talks about the prospect of giving this back to the states for democratic deliberation. But when he talks about democratic deliberation, it does run in one way, and it's not toward expanding access to abortion. I mean, he understands the democratic deliberation that will happen to further foreclose opportunities for abortion access. And, I think, this is the great white whale of the conservative legal movement. It is a galvanizing issue. It allows the conservative legal movement to not only come together around one thing, but to spin it off into other issues, whether it's voting rights, affirmative action. It all kind of clusters around this. And this isn't the end. This is just the beginning. And we tried to emphasize that when the decision came down. People in California, my friends in California were like, wow, this is terrible, but thank God we live in California. And I'm like, wait until you have a Republican Congress and a Republican president. You won't be happy to live in California because it won't matter. I mean, we're already seeing this at the state level. I mean, people talked about Kansas being this sort of glimmer of hope, like when, Kansas through a ballot initiative said, not for us, not in this state. Again, that's because there was direct participation as opposed to the people's preferences being mediated through representative government. Most states do not have a vehicle for direct democracy and ballot initiatives like Kansas had. Like most of the states are states in the West that might already be receptive to the prospect of expanded abortion access. And again, if this gets to the federal level, which it will, there will be a ban on abortion, and it likely will be rooted in this idea that there is a right to birth that stems from the 14th Amendment. So it's truly a personhood argument.
Yeah, I mean, we should note that there's legislation introduced in both houses, co-sponsored by many, many Republican lawmakers, precisely along these lines. There are, I forget how many Republican co-sponsors in the Senate of the Senate version of the bill. There's multiple dozens in the House. There's a bunch of different, obviously, abortion bans. There's, the Lindsey Graham 15-week ban, but this would go further. And also, it also just seems important to me to just note, and this has always been one of the weird things about, I think, the abortion debate, which I think has actually gone away in the same way that you find the Clarence Thomas dissent sort of clarifying, which is like, now we're talking about it. There was something always bizarre and to me like maddening and surreal about that period between 2011 when Republicans had taken over all these states and whole women's health and June medical services, in which they had gone at the issue by being like, we're just really concerned about how wide your hallways are. What?
We want women to have the best medical care.
We just care about wide hallways. Like, what
and women. We care about women in wide hallways.
Kagan has a great exchange, I think, in the whole women's health oral arguments, where she's like, obviously this is all pretextual. Like, what are we doing here? We know what you're doing. Why do we have to pretend otherwise? And I think to that point, the moral cosmology that produces an opposition to abortion, one which I'm intimately familiar with, having been raised Catholic, and my grandparents going to the March for Life every single year of their lives, was an incredibly animating cause for them, is that it is murder. And so it's just not going to be the case that it's going to be like, well, it's fine if the murders child murders happening in California.
Yeah.
Like, obviously that doesn't work.
No,
as
I
a
think that's
moral
exactly right.
commitment. We all know that. And like, clearly Amy Coney Barrett believes that it's murder. Obviously. Like, who are we kidding here? And clearly is not going to be fine with systematic child murder happening in 20 of the 50 states. That's obviously like an untenable moral situation if that is your first principle commitment, which it is genuinely for millions of Americans, including people on the court, including people who are serving in public office. They truly do believe it.
Well, so your wife and I are writing a paper about this whole idea of where did this democratic deliberation argument come from? And how does it pick up steam as sort of just a question of like an intellectual history of
You're saying specifically on abortion rights or just?
On abortion rights, not more generally, just focused on abortion rights for a volume on abortion rights. And again, I mean, it's just really telling for exactly the reason that you say, if this is the great white whale and abortion is murder, it can't be okay that Connecticut gets to be a state of child murder.
Yes.
Like, and so, I don't know if we hear that so much anymore. I mean, I think the democratic deliberation settlement that Dobbs provides is understood by everyone in the know. Like, this is just a way station on the way to nationalizing this issue.
Yes, although I would also say there has been, to get back to your point about politics as essentially an ultimate binding constraint here, which I agree with, they have touched the hot stove a little bit. I mean, they're not, I think it matters what happens in the midterms, honestly, but like, it has cost them politically, for sure. Like,
how?
I think they would be doing considerably better in the midterms if Dobbs.
They seem to be doing pretty well.
Yeah, good enough. But I think, Gretchen Whitmer is likely to be reelected in Michigan in a race that she's polling 8 or 9 points on Tudor Dixon that I think would be a neck and neck race in the absence of it. I think Mastriano in Pennsylvania.
Well, it also
I think
helps
places,
that there's like a major abortion challenge going on.
Yes, but I think in those places,
Okay.
I think if you look at those two places in particular, the two states where it is just definitively on the line, it is absolutely, I think, putting a tailwind at the back of the Democratic candidate. Now, again, everything that we're talking about in a polarized America is like 3 or 4 points. It's not 25 points. It's not like, well, obviously the Republicans are not going to win, but it is helping them at the margins.
But I do think it also, again, shows the fallacy of another argument that I think has always been made around the prospect of the court overturning Roe and Casey, which is that it would be better if they did, rather than incrementally chipping away at this. Like, if they did do it, if they like took the nuclear option and overthrew and overruled Roe and Casey, women would just be in the streets, like, and they would have such massive political consequences. And I don't think I've ever believed that, in part because I just don't believe in the capacity of the American public to hold on to one issue for longer than a month and a half. And I think we saw some sustained outrage, and then it's really dissipated. And so I don't think we're going to get the massive outrage reflected in the polls that people said would happen if they just finally did it, as opposed to the incremental chipping away that they were doing.
And I think you're right about the timing there. I think elections in July would have been very different.
And
I think we saw that. We saw that in the Kansas result.
It's not even that. I mean, like, this goes to your point about like, was the liberal a leaker? The liberals got nothing out of this leaking in May, because it just sort of like extended the period in which outrage could foment and then ultimately dissipate.
There's sort of 3 issues stacked atop each other in Dobbs, at least. There's the actual sort of future of abortion rights, right? The sort of holding. There's the kind of, atop that, there's a kind of methodological question about, compliant with our history and traditions, or whatever the heck his phrase is about, history and tradition. And then at the other level, the sort of most kind of abstracted level, above the sort of abortion rights question, above the methodological question, is the question of precedent, and how much precedent holds, and what the standard is for overturning precedent, and whether precedent actually means anything in any meaningful sense. And I'm curious to hear your thoughts about that at the highest level of abstraction, what Dobbs means for precedent, what it means for the Alito court in terms of precedent.
So
the Alito Thomas court, I should say.
Justice Thomas would say it's his court.
Yeah.
He's been waiting for it to be his. Like, the only person whose court it's definitively not is John Roberts.
Yes, correct.
Okay. Dobbs is just the most obvious iteration of the court playing fast and loose with precedent, but there's like tons of other examples even before Dobbs that we should have been attuned to. So, I mean, the overruling of Abood and Janus, I mean, that was actually interesting because that took a couple of terms for them to do it. So Abood was a case about public union dues, and it was decided in the 1970s, like no one had any problems with it. Then along came Justice Alito, and he's like, I have some problems with it. Like maybe it's a First Amendment problem. So he sort of cedes that. And then in the next case, which I think was Quinn, Harris versus Quinn, he's like, remember that time in the last case where I said that Abood might have problems? Like I'm citing myself again here. And like remember that Divinal song, I Touch Myself? He's like, I cite myself. And then there's another case in that 2016 interregnum, I think it's called Friedrichs, where they again sort of cite themselves, like, we said Abood was really problematic. And then finally in Janus in 2018, they're like, we told you it was constitutionally problematic, and so now we're just overruling it. So there was this sort of like, multi-step effort that they did, but it was really incremental and kind of under the radar, and unless you really followed the court closely, you might not have caught it. But they were definitely in an overruling kind of mood. Dobbs was just blatant in how they did it. And they'd been chipping away at the abortion right until it was basically a nub by June Medical Services anyway. So, it was just sort of a shot across the bow because Roe was such a symbol. But even in the last term, like think about Kennedy versus Bremerton School District. This is the praying coach, right? We could spend a whole hour talking about the comparison between Dobbs and Kennedy. So like in Dobbs, like women have no privacy rights, but in Kennedy, a man is actually a private space as long as he's praying. He's legit. He's
even
a
on a football field.
Like even on a publicly
I'm
owned
sorry,
football
did you
field.
guys all
It's a
see me
church.
here?
It's a church. It's basically a church. So I mean, it's just a kind of wild comparison. But one of the interesting things that happens in that Kennedy versus Bremerton School District opinion is that the court basically overrules the Lemon test, which is a long-standing test from under the First Amendment, and they overrule it, not explicitly, but it's been abandoned. Like, well, it's only been abandoned because you won't use it. Like, that's why it's been abandoned. You won't actually apply it. And they're like, well, like we said, it's abandoned. And like they leave it by the wayside. And you could imagine, so the West Virginia case, West Virginia versus EPA, the case about climate regulation, it's so interesting in that case that you never hear the words Chevron versus Natural Resources Defense Council. And I imagine in the next big case that concerns the administrative state and climate change, we'll hear about how Chevron's been abandoned because they refuse to talk about it in West Virginia versus EPA. I mean, this court is like literally so canny and I would say diabolical, but we're on tape. But they're just so good at how they do this. And like, unless you're watching every move, you will miss it.
I guess the question is what it means at a deeper philosophical level about precedent and how important it is. Because the thing that always happens, right, and John Cornyn did this after Dobbs, that they will say, and not completely preposterously, they'll say, well, you liberals obviously like Brown overruled precedent. There's all kinds of cases that overrule precedent that are good because the existing precedent sucks. So when the test, my personal like Chris Hayes test for whether I like precedent is like, is the decision good or bad? And is the precedent good or bad? That's my test. Like, now that doesn't, like that's-
Chris did not go to law school.
Yeah, exactly. I did not go to law school. It has no methodological rigor, but I would hazard as a sort of increasingly hardcore legal realist that that's literally everyone's test. You go to law school so that you can write an opinion or hire clerks to write an opinion that justifies precisely the Chris Hayes test on overruling precedent with a lot of fancy citations, which is like, is it good or bad? Well, I think it's bad, the precedent, so yeah. I think overruling it is good. And ultimately, Stevens, I think, is very compelling on this about why precedent is important, because he really was pretty deferential to it and wrote a lot about why it mattered for judges. And I think I used to find that a little fustier than I do now. But I guess my question to you is like at a deep first principle level, do you really care about precedent, or do you just care that the court is abandoning good precedent? You know what I mean? That it's just like untethering them.
I mean, to be clear, I've never said I thought Roe was a good precedent. right? I mean, I think Roe doesn't go nearly as far as it could. I think Harris versus McRae is a travesty. I think Roe secured rights for some women, but not all.
Harris McRae is
I'm sorry,
is
I'm
the
like
Hyde
talking
Amendment,
like you were
right?
all in my class. Harris versus McRae is the Hyde Amendment, which basically prohibits the use of federal funding for abortion except in certain limited circumstances. But what I respect about Roe is that we have oriented our lives around the availability of it. And what troubles me about this sort of stare decisis is for suckers moment that the court seems to be engaged in is that we can't predict
Right.
where this goes unless we think about the ideological underpinnings of the court and its personnel. Like, it used to be the case that you could be surprised by the court. Like, in Casey, like everyone expected Roe to be dismantled, but this trio of Republican appointed justices come in to save it because they believe in precedent and they believe that there is something really problematic of just jettisoning something because the court's personnel has changed, or giving the impression that you're jettisoning something because the court's personnel has changed. Like, the rooting principle of the Anglo-American legal tradition is this idea of incremental change over time, distinguishing cases on the fact, not on the basis of who is on the court or who's making the decision. And the skepticism of precedent, the sort of fast and loose, interest in stare decisis, I think completely undermines all of that. It undermines predictability. We are going to see wild lurches. I mean, just look at the free exercise jurisprudence. Like, that has changed so markedly from 2017 to now. I mean, it is astonishing. And it's also precipitated changes in how we view the Establishment Clause.
Yeah, and I think that again, this sort of temperament question, or sort of small c conservatism and judicial minimalism and not legislating from the bench, like, it's all swept up in this same thing, which is like, this idea of an activist court, again, to get back to what I was just saying before, like, it's a little bit of like the bad rulings are activist and the not bad rulings are not activist. But in the case of like the web designer who doesn't want to make websites
303 Creative.
For websites for gay couples, doesn't have a web business and hasn't had to give their services to any gay couples. There's no injury.
Yeah.
It's an invented issue. It's teed up for the purposes of the court creating law, and there is no actual, again, I didn't go to law school, but like, what is your injury, dude?
Yeah.
Well, I don't know, the thought that someday a gay couple might make me make them a web page?
So, I mean, part of this is, again, like, there is a kind of agenda with certain issues on it, and these are cases that I think, like, are concocted for the purpose of getting these before this court, because it's understood that this court will be hospitable, I think, to those questions. And again, you saw this in the affirmative action case. I mean, Justice Jackson was like, last time I checked, in admissions protocols, there are like 50 different criteria that people are assessed on, like, their family background, where they live, like, if they have work, how much money you can donate, are you the scion of a family whose name is on a building?
Yes.
How can you tell if someone has been admitted solely because of race? And if you can't, how have you been injured by the use of race in the admissions process? And I mean, I think it's a very telling question, but the reason why this is back in this court again after 2016 is because some group wants it here. And they want it here because this court is going to do with it what they want to do with it.
I mean, I think at a broader reform level, to me, the way to think about this, at least the way that I thought about it, is, again, getting back to this sort of Clarence Thomas, like, the truth is out about that dissent. And we're going to go to questions in about 2 minutes, I think, for folks that might have one. But to me, it's like, okay, fine. If we're going to have this kind of super legislature, right? Like, well, then, God, we need term limits, and we need to regularize
or
the
we
means
need
by
representation. Which these, I mean, like,
right, or
like
something.
Leaving
it
that
can't
aside.
be just the like. It can't just be the like, who gets cancer sweepstakes for everything. I mean, that's literally what it is right now. That is literally what it is. Like, if some set of horrible deaths happened at a certain time versus another, that will be completely determinative of the constitutional rights that Americans have. Full stop. It is an actuarial rolling of the dice every day, all day, which is completely impervious to any form of democratic oversight or accountability. That's obviously totally untenable. If you're going to have a super legislator, then they have to have terms. Those terms have to sync up in some recognizable fashion with natural elections. And then you have to know that, like, okay, well, we're voting for this person, and then we're going to get this super legislature that gets these seats because they're connected to them. But the way we have it now is truly perverse and sick.
So I think I wrote, it must have been around 2013, an op-ed for the New York Times against term limits, and I have since, I think, recanted. I mean, I still think that not because of anything here, but actually because of Justice Ginsburg. Like, I know this, like, sacrilege to say this here at NYU, but I mean, I think it was a mistake for her to stay on as long, and like someone should have.
Obviously, it was a mistake.
Well, I mean, I thought it was a mistake even before 2020, but I think there needed to be some kind of external motivator to have her step down.
Right.
And to be clear, like, I can totally understand why someone who, for the early part of her career, had been the victim of pernicious and persistent gendered discrimination would be reluctant to give up her seat at the top of her profession. I mean, I get that. I mean, there are costs to gender discrimination, to be sure. But I wish there had been an external kind of hook to propel her to rethink and indeed to leave her seat, and to also lower the temperature on these confirmations. I mean, we wouldn't be having this discussion about, did Amy Coney Barrett lie? Did Brett Kavanaugh lie? Did Neil Gorsuch lie? Did Sam Alito lie when they said they would respect precedent, if everything didn't turn on these people in these seats, like these sort of accidents of birth or death.
And to the point about Breyer, I mean, there was
retire Breyer.
Well, right, but also it was like he took a little while, and like,
oh, we were trying, like, strict scrutiny was like, dude,
I know.
You can be on the podcast. You can have your own special, we'll call it Mensch on the Bench, and you can come answer. And he was like, no thanks.
Well, but also, again, to come back to these sort of the weird actuarial vagaries here, it's like, I'm pulling this from random, but I think like half the Democratic senators are over age 90, and so I mean, that's a joke, but I think
it's funny because it's true.
But the point being that it's like Vermont has a Republican governor, and Patrick Leahy is 87 or 88,
and has been hospitalized.
I want nothing but the best for Patrick Leahy, and like.
But I also want the best.
But it's also
for me.
like this is a crazy thing for all of us to just like walk around with, like, when the natural effects of living in the world happen is going to be determinative, and the Democrats got lucky essentially, but there's a universe in which the Senate flips, and you can't confirm Ketanji Brown Jackson. So all of this seems to me like totally untenable. I totally agree with you. It stacks this kind of freightedness on all of it, because it all feels like, and you saw this among Republicans when Scalia died. Their sense, and I don't think this was crazy, because I think I probably would have had the sense if I were in their shoes, was like, this isn't fair. It's not right that just this happenstance, which is that he just happened to pass away at this moment, means that now it's your seat and not ours. And like, there's something to that sense they had. There really is. I mean, I think people felt it with Ruth Bader Ginsburg. Like, why is it the case that this is the thing?
See, I disagree. I'm just sort of like, again, in the absence of term limits, if you die, your seat gets to be filled by the president. And I felt that when that happened with Justice Ginsburg. And I said this
a lot of people did not.
No, I know.
Most people.
I was an outlier on this, and I'm fine, happy to be an outlier. But I was like, I don't think, we need to listen to her deathbed wishes or what she told her granddaughter. Like, it's the president's, in the same way I felt strongly that Barack Obama had an entitlement to nominate and have a hearing for Merrick Garland, I guess Donald Trump can fill the seat.
I think that's consistent. All right, we'll take a few questions.
Yes, Michael is looking at us expectantly.
I think you just come up to the microphones, is that correct? There's 2 microphones here. It's always hard to be the first one, but there we go.
Here we go.
All right. Thank you both for that really wonderful conversation. My question is, Dobbs was kicked off by an abortion clinic challenging a statute that was clearly unconstitutional. But I'm asking, I guess, in retrospect, was that a mistake, given the fact that there can only be a Dobbs decision in the Supreme Court if there's a case there for them to adjudicate. And more broadly, I think going to your point about how there's not going to be many surprises from the Supreme Court, what is the duty or role of progressive organizations to kind of play keep away and try to stop circuit splits from developing?
Great question.
That's a great question. I mean, I guess we could play Monday morning quarterbacking and, you never should have brought that case. Right. But then what would all of those people in Mississippi, what would they have done? Right? And the challenge that was brought by Jackson Women's Health Organization actually did manage to get the law enjoined for a number of years, right? And enabled abortion access in a state that has a large Black population, and thousands and thousands of Black women were able to get reproductive care during that period. So I don't know if it was a mistake. I mean,
well, but to me, okay, but I totally on the sort of retroactive, but it does to your question. It does seem like there's a real strategic question going
for
forward.
sure,
Like
yeah.
What impact litigation looks like under these circumstances.
Yeah.
And I remember people were mad at
David,
Boys Olson.
David and Ted.
Got there.
Yeah.
Boys and Olson, when they brought the challenge.
And then they were
constitutional
happy.
challenge. And then they were happy because it worked, but it could have gone the other way. And then it's
Yeah.
like, well, now you shut the door. And I've seen this with voting rights cases. There's all sorts of internal dissent. There's been anger at Mark Elias for some of the cases he's brought.
Yeah.
People think that, to your point, that the issue isn't ripe enough, or you're going to get a bad. Like, it does seem to me that the question of what suits you bring and where, with this court as the ultimate endpoint, has to figure, right?
But I mean, I think you're already seeing some changes in litigation strategy. I mean, there's just much more activity in state courts now, and also legislative policy lobbying.
Well,
at the
hopefully we
state
can
court.
yank state court jurisdiction in Moore v. Harper, so we can get that out of their hands. Because
I mean, again, not all states are the same.
Right.
But I mean, I think you're already seeing a shift. It's such a good question, though. I mean, this really is the sort of ethical quandary of impact litigation. Not only like, who are you representing and are you faithfully reflecting their wishes, but are you affirmatively making the situation worse for more people just because you can't predict how everything's going to fall?
Sorry, okay, there we go. Hi, my name is Simone. Thank you for speaking with us today. So when you had mentioned in prior cases that there seemed to be a reliance on precedent and that stare decisis was taken seriously, and I think something I've been thinking about recently is this divergence of what truth is and what it was understood to be, and that there's a separation of like, there's a truth for one people and there's a truth for another, whereas in the days past, meaning like the 70s, there was one truth. And you're seeing that in like the popularity of platforms like Truth Social and like all of these different like versions of and disinformation and Twitter, and now Twitter is now owned by a man who I don't think has any like conception of what his version of truth, how that aligns with everyone else and what should be. And so I'm wondering how you think this is going to, this like separation of these two truths are going to affect cases going forward at the state level, where you see the impact, and if anything, is there anything to do about it?
This is your people.
well, I think it's a great question. I mean, so the one place that I think you can look to like a concrete answer in 2020, where the courts end up being sort of ultimate arbiters of both facts and law, right, and establishing the factual record, is on all of the election cases, right? So there, like the courts really hold as a kind of definitive arbiter of the factual record, because there is no widespread fraud. There just isn't. And in the 60 cases that get brought, they keep saying like, show us the evidence for the widespread fraud, and they keep coming up empty, and they keep coming back being like, tossed out of court, right? So in that case, but again, to go back to your point, which I think is quite astute, like to me, that is a sociological fact as opposed to a legal one, which is to say an insufficient number of the judges had brainworms such that, and I'm serious, such that they found And this was true throughout the legal regime, right? Like there was a limited amount of brainworms, and enough limited amount of brainworms, it just was in the head of Jeffrey Clark and John Eastman and Kenneth Chesebro and Rudy Giuliani, and like a small enough amount of them that there was like Team Normal and Team Brainworms. But the brainworms are that's just a sociological fact about how many people subscribe to the Truth Social version of events. There's a universe in which there's just enough judges that have the Jeffrey Clark, Kenneth, John Eastman view of the world. They're just, I mean, John Eastman's a credentialed dude. He's a Supreme Court clerk. Like,
Dean of a law school?
He's dean of law school. Like he could be a judge. And so, yeah, to me, that's the real question, is like this breaking point, right? Like, does it hold against the kind of epistemic onslaught that you see? And the place where that really cashes out to me in jurisprudence is on this question of the historical record, which is of course ludicrous, because one of the obvious chief methodological defects of originalism is that it deputizes, again, very bright, very accomplished 25-year-old clerks to be amateur historians and go through the historical record. And it's like, well, you can find whatever you want in the historical record, obviously, and particularly with the resources of the Supreme Court librarians, who themselves are incredibly adept and smart. You could go to them and be like, give me this, and like they come back and it's like, oh, look, that's in the historical record. And the idea that like the historical record says one thing is ludicrous. And so what you end up is you just end up cherry picking your examples so that they support your argument. You can cite back to the historical record, which is very similar to what happens in the news, right? Like there's a lot of things going on at any time. Like I could spend all of my television show, and I just did a riff on this, like talking about like the horrible crimes that people in Oklahoma are committing. And like, yeah, that would be true. It would also like be obviously have an agenda to like show people that Oklahoma's a bad state and the Republican governor there sucks. And I don't do that because that would be useless. But you know, you can do a lot that misrepresents the full totality of reality that is never actually
untrue,
flatly untrue, right? And that's sort of the other conundrum. Like the problem of the election lawsuits was that they were flatly untrue. But there's a more sophisticated version that doesn't run into that problem that can still be incredibly manipulative.
And I will add to that, you know, one of the real problems I think that Chris's question raises about the courts is that there's been so much amicus activity, especially around these hot button issues. And there's at both the lower courts and at the Supreme Court, and there really is no mechanism for verifying what is submitted in amicus briefs. Like, you know, there's no one like, you know, fact checker. There's no one like Steve Kornacki's not there, like, you know. And so you can basically say what you like in an amicus brief, and you know it will be received by the judge or the justices, and you know you can be an historian, like maybe not an historian, and you can submit these briefs. So I mean, I think that's a real question. Like, how do we limit the influence of amicus facts on the record? And how do we? Again, I think it would be really interesting if, in the confirmation process, we not only asked prospective judges to disclose their financial information, as we do, and I definitely read all of that, to also like, what are you reading? What is your media diet like? I actually want, and maybe all of them would like, I obviously read both the New York Times and the Wall Street Journal. I would say I read Us Weekly, People Magazine, and a lot of other things. But I actually would like to know, where are you consuming your news? Like, who is filtering your news?
I mean, I can tell you where Sam Alito gets his.
Oh, 100%.
I mean, there's some real tells.
Cancel culture.
Yes, exactly.
It's the first tell.
Great. I wanted to ask about something that I know is brought up here, but I don't think gets discussed enough in discussions of abortion and other constitutional rights, and that's religious beliefs underpinning these debates. It seems pretty obvious that a large chunk of this country, and arguably a majority of the Supreme Court, has a deeply held religious belief that abortion is murder. And I think for a lot of people, this belief extends to things like same-sex marriage is sinful, or same-sex intimacy and contraception are sinful. And I guess what I wanted to ask is, given the drastic erosion of the Establishment Clause we've seen, the expanse of the Free Exercise Clause, and generally the rise of right-wing Christian nationalism, how far are we from a Christian theocracy, really?
I'm afraid of your question. I'm genuinely afraid of your question. I don't know how far we are, but I think all of the things you identify are really they're true. And, I think it's something to grapple with. And I think it's worth thinking about, like, we were a country founded on the prospect of pluralism, and specifically religious pluralism, right? I don't know if this is the country the founders would have anticipated or expected, even though many of them would have, denominated themselves Protestant. I think one thing that is actually really interesting, and I'll relate it to a case. So in 303 Creative versus Alentis, this is the sort of masterpiece cake shop redux where the court's going to think about whether religious freedom trumps civil rights protections for same-sex couples. The appellant, Lori Smith, who runs that videographer website design business, actually presented two questions on certiorari: a free exercise claim and a compelled speech claim. The idea that Colorado is making her say she basically likes gay couples when in fact she doesn't. The court only granted cert as to the compelled speech claim. It did not grant cert on the free exercise claim, and you might know why. It could be that they were like, we did so much work on free exercise in the last term, we don't even need to touch it. Or, and this is my cynical thinking, there have been so many free exercise responses to Dobbs, like from Jewish people who argue that the Torah compels respecting the mother and her health above the rights of the fetus, that they don't want to touch it right now.
That's interesting. Yeah, I mean, just quickly, I will say that I think that I don't know the answer. I think that I feel very cross-pressured on this, because I do think that, like, the principles of pluralism are really important here, and I do think that, like, you saw this in the Amy Coney Barrett stuff, where to me both of these sort of twin imperatives were at tension. At one level, it's like Amy Coney Barrett can believe whatever she wants to believe and worship in any way she wants to, and that can't be held against her because we live in a liberal pluralistic society and it's gross to do otherwise. At the same time, it was like, it's a little weird that we all have to pretend we don't know what she thinks about abortion. Like, we all obviously do. And so those two things
like
happening
she held
at
up the blank pad. This is like, I'm a blank slate on
yeah,
abortion.
it was just like, it just was, so that was, to me, that was where that tension was. Because it was, again, like, I come from this Catholic upbringing, and it was a little gross, I think, a little bit of this, like, Handmaid's Tale stuff around her. And it's like, buzz off, you know what I mean? Like, that's the rules that we create for a liberal society is like, you don't go around saying like, well, it's weird what they do on Sabbath, they won't touch lights. It's like, F you. No, like that's in their realm, and people get to believe what they believe, and they get to pray 5 times a day. They get to have beliefs that are to you completely bizarre. That Jesus came and visited the Native Americans first, like that's a belief, a tenet of faith. Like, you could think it's nuts, but that has nothing to do with any of us. At the same time, like, when the commitments, particularly of the church and particularly of religious Catholicism on this specific issue are so clear and obvious, it's very weird to have to kind of go through the sort of suspension of disbelief that, like, how will Amy Coney Barrett find on the first big abortion case?
So again, one of the things I really admired about when Justice Jackson accepted the nomination and when she talked about her appointment, she outed herself as a person of faith. And I thought that was, one, not surprising to me in the Black tradition, like that she attends church. She grew up attending church. I think lots of people in the Black community have. But she made clear that faith is not just for conservatives. Like, we all can be faithful. And it was a reminder that we do live in a multi-racial and a multi-faith democracy. And, the real question, I think, going forward is like, do we see the same solicitude for faith of all kinds of faiths from the court as we do for Christianity and, Catholicism, or, the kinds of issues that might redound and sound in the tenets of those faiths? And so that, I think, is the broader question. Michael is telling me that we are out of time.
All
so
right.
Let me first say thank you, Chris, for coming down to NYU. Chris does not have a law degree, but I think we should see about getting him an honorary one. So I'm going to talk to the dean about that. Thank you so much for hosting us today, Latham & Watkins, which sponsors the forum, which is a great opportunity for us as a community to come together and talk about all kinds of issues. So thank you so much, students, for joining us today. And I hope you'll come back at 5 o'clock when I again sing for my supper when we talk about femtech. So please come back and see us again.